Hello, welcome to Tom's Aviation and Firearms channel. Today this is going to be a looking at on firearms and basically dealing with firearms law. And I will talk about the different laws that are up here and how gun control laws came about. We'll also talk about the Second Amendment and my interpretation of what the Second Amendment says. I would like to start off talking about the history of gun control. And it appears that one of the first federal laws that came into existence was the National Firearms Act of 1934. Some of the background on that was there was a lot of prohibition-type crimes going on. You had the St. Valentine's Massacre and several things. So under President Roosevelt, he was a little bit socialist, decided to pass a bill and try to get it through that would eliminate machine guns, short-barreled rifles, short-barreled shotguns, and pistols and handguns or revolvers. Now, he wasn't exactly trying to prohibit them. What he was doing was going to tax them for possession, to own them or have possession. And that was going to be $200. That was equivalent to about $3,800 in today's money. And it went before Congress. Well, as this stuff is in there and debated, pretty much they went along with everything, but they would not go along with handguns. So pistols and revolvers were taken out of the act before it was passed. The NRA president at the time, he didn't really see any problem with restricting those different firearms. While they're not prohibited on the federal level, they are restricted with a tax stamp on them. The next law that came under federal law was the Federal Firearms Act of 1938. And what that required was that anyone manufacturing or a dealer in firearms had to obtain a federal firearms license in order to conduct business. Also, there was laws on importing and exporting firearms. This stayed into existence until the 1960s, until replaced by the Gun Control Act of 1968. In 1939, there was a Miller versus the United States Supreme Court case that came before it. And Miller was had possession of a short-barreled shotgun, which was basically any shotgun with the barrel less than 18 inches. He tried to say that the National Firearms Act was unconstitutional, and it did work its way up there to the Supreme Court. However, about 1 month before the Supreme Court, Miller was murdered, and so there was really no defense on his part of not for violating the National Firearms Act. The Supreme Court ruled that a short-barreled shotgun was not a weapon. It was used in war, was not part of the military, and ruled that Miller did, in fact, was in violation of the 1934 Federal Firearms Act. Therefore, there was not really anything that was coming out of the case as far as anything, as far as decisions, as far as pro-gun or anti-gun at the time the law stood. The next one that we want to look at was the Gun Control Act of 1968. There were some assassinations in our country, of course, John Kennedy and Bobby Kennedy, and decided to make a more comprehensive package that would eliminate some of this stuff. They was going to do away with mail orders, which was done. And of course, felons could not own any firearms, couldn't possess them. That came from the 1938 Federal Firearms Act. So the Gun Control Act of 1968 came about During that time, not only did you have to turn around and dealers had to have logs of pistols, so they also had to have logs of ammunition. If anyone came in to buy ammunition, you had to record it in a book. I obtained my federal firearms license in 1983, and that was part of the law then. I actually had two books, one for the transfer of firearms, also one for ammo. In 1986, there was a Firearms Owners Protection Act that was passed. This gave some relief to the Gun Control Act of 1968. One of the things that was removed, that you no longer had to log in sales of ammo. But one of the things that happened on that was also a bill was on there as a rider, and that prohibited any new civilian firearms coming into the pool. So in other words, we had the National Firearms Act. There's a registry that has all machine guns listed in that, and up to that period, new machine guns could be added for the civilian market. After 1986, we could no longer have machine guns from the civilian market. Any manufacturer of machine guns had to be either for military or law enforcement. In 1990, the Gun-Free School Zone Act became law. And basically that prohibits unauthorized individuals from possessing a firearm in a place believed to be a school zone. Now, there is some exceptions to that. If you have a concealed carry permit issued by your state, then you can carry them in a gun-free zones. So that does apply in Kansas. This was trying to make so-called safer for schools by not having any guns in there. The next item that we want to look at was the 1992 Brady Act that came out, and in that one required background checks for anyone purchasing a handgun. Not only you had to fill out the form, now we had to get a background check. And you had to call that in and get that approved before you could purchase a firearm. The next bill that I want to look at was the 1994 assault rifle ban. Now, there was at that time no real definition what an assault rifle is. It is something that was defined in the 94 bill. And basically it was any semi-automatic that had a detachable magazine and had two of the three items, which could be a pistol grip, a flash suppressor, or a bayonet lug. So any gun that had stamped on it, Colt, AR-15. It was also banned by the title of the firearm. This existed for 10 years. Also, magazines, anything capacity greater than 10 rounds, was also eliminated. You could possess them and everything, but just no new manufacturers of these weapons. So in 2004, the bill actually expired. And they could only get it passed with a very narrow margin with the expiration date on it. So it lasted for 10 years. During that period, the FBI showed there was no significant decrease of any crime because of this. And this appeared to be a case of not really doing much at all for crime. One of the things you look at FBI statistics, and they don't even track any weapons as far as assault rifles. I'll use the definition from the 1994 because in 2004 that definition went away from the Federal Firearms Act. Some states still have it, but it is not even defined in the federal law now. Dealing with this, what they found that there is something like right around 400 murders a year committed with rifles. Now, out of that, the AR-15 or AK-47s, they don't really define them, but there are going to be subsets of this. If you look at blunt force objects that kill people or murder people, it's above 500. So we're probably having much more murders committed with hammers than we are with assault type. The next act that was passed that was the Protection of Lawful Commerce and Arms Act in 2005. This was probably a good act that was passed because it limits liability of gun manufacturers or firearms dealers to only stuff that they would commit or had problems with. It could not be that if someone or a third party used the weapon in a crime that they could be sued because their weapon is in this. So we have that Protection Act. Now, is that the only industry? According to our president, that is the only industry that has it. However, if you do some looking at it, you will find the pharmaceutical industry, the automotive industry, and there's several that have this liability protection. You're not responsible for what your product does in a crime because someone uses it in a... It also shows that there's been several Supreme Court cases that looked at the Second Amendment. We have the Heller case, the McDonald case, and I'm not going to pronounce this correctly, Cantino versus Massachusetts. So it looks like the court is being favorable to interpreting the Second Amendment. I am going to now talk a little bit about the Second Amendment itself, and I will bring up a new slide here. Looking at the Second Amendment of the Constitution, which is really part of the Constitution since it has been amended, it states a well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. It looks like to me when I look at this, it seems to be to me very clear. There may be a few words in it that maybe not used a lot today, but let's look and go through it. First, a well-regulated militia. What is a militia? It's basically citizen soldiers in time of need, and that's the way it was back then during the Revolutionary period. Regulated. Regulated is a term we don't probably use today, but it meant organized. So basically a well-organized citizen soldiers being necessary to the security of a free state. This makes a statement. It is not only the reason for the Second Amendment, but it is one reason. That at best, the next part of this, there is a comma, and now we get into what the Second Amendment actually says, is the right of the people to keep and bear arms shall not be infringed. What is people? Those are people and not government. Our president has defined people in one of his speeches as being the government besides the citizens. I take issue to that because people to me mean humans. To keep and bear arms, arms is usually considered to be either small arms or it could be larger weapons. Shall not be infringed means they shall not pass any laws or anything to limit the right of the people to keep the arms. That is my looking at it. I'm going to explain a little bit from what I see. I have read several things about some people that have defined this in the law community and the way it has been looked at. One of the things that, and there's a lot of issues on this and how they read it. They read militia, it means National Guard or something, and it has to be under regulations, and the people is not an individual right, but a right of the states to have National Guard, and the federal government would not infringe on that. That is sort of stretching to what the meaning is. And there is an interesting article. You can find it on the internet. It is called The Embarrassing Second Amendment. It was written by a person back in, I think, about 20-some years ago. It can be found. He was a law professor out of Texas, and it was published. And it's an interesting article to read. The other thing I want to talk about and what people do, there's a book that was written in the Renaissance time. It was called The Prince. It was written by Machiavelli. And he coined the term, the ends justify the means. Therefore, if I want to eliminate guns and have gun control, then any means to do that is okay as long as that's the end product. Gives me what's doing that. So that gives me the right to lie, misrepresent, use propaganda, misquote statistics. I don't think that's really the proper way to look at it. I think reading the Second Amendment is very clear, and it constitutes the right of the people to keep and bear arms shall not be infringed. There is a lot of good pro-Second Amendment channels on YouTube. They're very worthwhile to look at. They're going to provide a lot more details and stuff that's going on that I'm doing. I'm just making my statement. I don't want to be too political on this, but however, I believe in reading the Second Amendment just as it says. To me, it is clear language. So this is going to end my discussion on the Second Amendment, and hopefully I will continue. But I thought I would put this into the program or my channel just to show where I stand on this, and I'll probably keep most of the other stuff into a technical means and discussions on the rest of what I present. Thank you for listening, and have a good day.